Hello, and welcome to Chesapeake Public Schools Family Empowerment Webinar presented by the Office of Family and Community Engagement. I am April Darnell, one of the FACE specialists. Our office, which is under the Department of Engagement, seeks to create meaningful partnerships in order to inspire, engage, and empower families, educators, and community agencies to support the initiatives of Chesapeake Public Schools. We are typically available Monday through Friday from 8 a.m. to 4 p.m. and can be reached by our main phone line at 757 482 5923 or face@cpschools.com. We are excited to offer our families a course catalog entitled Peak Parent University that outlines all of our events for the school year. You can also catch up on pre-recorded webinars, access a wealth of educational resources, and make community connections to promote your family's well-being. Please visit www.cpschools.com and search Peak Parent University. We are excited to have you join us tonight for information regarding future financial planning for parents of children with disabilities, co-hosted by the Department of Exceptional Learning. Before we begin tonight's webinar, I want to let everyone know that we are recording for use on our YouTube channel. Only our panelists will be seen and recorded. If you have any questions, please place them in the Q&A at the bottom of the screen. We will answer all questions throughout the webinar. At this time, I will turn the program over to Dr. Frankie Dampier, Transition Specialist for Chesapeake Public Schools, who will introduce our guest speaker.
Good evening. Thank you so much for attending our presentation this evening. I am Dr. Frankie Dampier, and I am one of the transition specialists for Chesapeake Public Schools. I have the pleasure of introducing our other transition specialists who are also here this evening to help facilitate and capture our questions that you may have this evening. We have Ms. Regina Stowe, who is a transition specialist serving the schools that you see on the screen: Indian River High School, Oscar Smith High School, Oscar Smith Middle, Indian River Middle, and CSEP Reach Center. And then Ms. Christina Trinello, who is serving Western Branch High and Middle, Jolliffe Middle, the Chesapeake Career Center, the Chesapeake Center for Student Success, and also Crestwood Middle School. Unfortunately, Ms. Sharon Willis is not able to be with us this evening, but she serves Grassfield High School, Deep Creek High, Greenbrier Middle, Deep Creek Middle, and Hugo Owens Middle. Now this evening we have the honor of having our guest speaker, Ms. Shannon Lehman Pecoraro, who will be presenting for us our presentation on future and financial planning for individuals with disabilities. And I will now turn it over to our guest speaker.
Hi, everyone. All right, let me get this shared. Okay, so my name is Shannon Lehman Pecoraro, and I am what they call a certified elder law attorney. And there's only about 500 of us in the country. And essentially what our focus is, it's all things death and disability. And so it's often a common misconception that whenever we use the word elder law, you know, why do we do special needs work? But really, if you look at it, it's about the benefits programs and, you know, what's available, and the needs of those with disabilities often mirror the needs of those as we age and, you know, later on down the road too. So anyways, that's a little about me. I've been doing this for 12 years. And my favorite thing to do is actually work with my special needs families. So I'm glad to be here today for you all. All right, so let's start off with what is special needs planning, okay? And so a lot of people have heard about special needs trusts, but I always say that's one tool in the toolbox. And basically what we need to really look at is what is the financial plan and really what's the long-term personal care plan. I actually met with one of my clients who I've been working with for about a year earlier today, And we're finally on that discussion. All of his kids that, are over the age of 18 now. And we're really looking at is, what's that next stage? His kids are now off, two of the kids are off of college, the other one's at home. And it's really about planning what it's going to look like for the one that's at home. And, what does he want for the other kids in terms of caregiving? And I always tell people there's not a right or wrong answer in what that looks like. It's about what your family is accustomed to, or, what they want. And so, I have two major trains of thought. The first one is usually, well, no, family's going to step in and take care of family. But I do have other families where they essentially say, I want to build a support system independent of other family members. So that way the other, my other children or whatever can, live the life of their dreams and aren't tied down. So there's no right or wrong answer there. And I've helped build plans in both areas of the spectrum. So with that said, in order to do so, it's important that people understand public benefits. So while there are a lot of estate planning attorneys out there who know how to draft a special needs trust, they're very unfamiliar with benefits, and in particular Medicaid. And so what I often see is the inability to understand the criteria for certain benefits. So for instance, if somebody's on Social Security disability instead of supplemental security income, you can have $1 million worth of assets. And so I don't need a special needs trust in order to protect that benefit. Similarly, if I have somebody on CHIPS Medicaid or expanded Medicaid coverage, that's 100% income based. There is no asset test there. And so there's no major planning even to protect that benefit. And so it's understanding and making sure that the benefits that we're looking at all interplay with whatever the plan is, understanding the tax laws and implications to individuals, and then obviously understanding those tools that are available. The other important thing that I do not overlook is that the practitioner or the attorney has to actually understand their client or the client's child. And you have to understand what is their actual disability. And whenever I talk about disability, I talk about the functional disability. So I am a firm believer that, and partially because I know the Social Security definition, but that a diagnosis alone does not create a disability. And so a lot of times I'm asking parents to tell me about their child. So like, for instance, I just met with a family earlier today. They have a 6-year-old with muscular dystrophy. Well, where is he at in that? Like, is he in a wheelchair now? How far has he progressed? These are things that I need to know because I need to look at exactly what is going to be detailed out in the future. I need to know what their limitations are. What are their strengths? What is the family's hopes and dreams for this kid? So that way we can just build a good, solid plan. Whenever we address the plan, we have to address what our principal concerns are. So number one, planning for the disability. So for the family with this child with muscular dystrophy, it's understanding that we've got a shortened life expectancy. We are going to have wheelchairs and everything else in our future, and kind of what can we do now in preparation for that? Right now, he's a healthy 6-year-old, but we do know that it's going to be coming on down the road. Housing options. One of the things that I often talk about is, where is this particular child that we're talking about going to live? Once again, no right or wrong answer. Do you want the house to be theirs? So that way any care support has to be centered around the child. Are we going to give the house to the caregiver with the hopes and expectations they're going to take care of this kid? Or are we going to look at outside placement? Are we going to look at group homes or independent living situations with caregivers? And so kind of talking through that, it's interesting because my friend Jim McCartan, who practices outside of Atlanta, I just got an email from him today because I'm going to see him next week. And he is actually trying to build a national database right now of what are the residential options available for each state. So I have to, pull that out for him. And Virginia does have some interesting little options in terms of being able to provide an individual with an apartment, but then provide whatever level of support they need inside there. So for those of you who are familiar with Hope House, that's one option that they provide to they try to promote as much autonomy as what they possibly can, and make sure that there's really a transition for whenever the parents aren't there anymore. When we do talk about housing options, I often try and say we need to start looking at that plan before we're in a crisis mode. And that's because depending on certain diagnoses, change is, I mean, well, change is hard for all of us, but certain diagnoses, it's even harder. And so whenever I have certain diagnoses, trying to make that transition while the parents are still alive and can help in that transition becomes super imperative, because if I've lost the parents who were the stable caregivers, plus now I'm throwing somebody into a new environment, it creates a lot of chaos and problems. Been there, I've done it multiple times, and it's not fun. How are we going to pay for long-term care? What benefits are available? Whether or not it's, we need in-home care, whether or not it's facility care. As we know, this is a very expensive process. What other assistance may be available, whether or not it's caregiver support, just any other things that are out there. We do have to talk about tax and estate planning, because we need to make sure that there's a plan in place so that benefits are not disrupted at the death of a parent. What are your fiduciary duties and obligations? What must you do, and what are you tasked to do, especially if you're a guardian and conservator? And then we want to maintain public benefits eligibility and also provide support for caregivers. All right, so this next screen is, if I can get it, this next screen is what I look at for public benefits. And so the benefits on the left-hand side are all needs-based. And so there's either an income or some sort of asset test attached to them. The ones on the right-hand side, you're entitled to them as long as you meet the eligibility criteria. So really, whenever I start looking at planning, it's the things on the left, in particular Medicaid, that really becomes important. One of the important things when we start talking about transitioning into adulthood becomes the latch in on SSI. So it always amazes me the number of parents that don't latch into SSI kind of immediately upon age 18. And a lot of times it's like, well, we don't want to deal with the paperwork. We don't want to deal with going through the process right now. We don't need the extra $900. But what we're going to be talking about now is actually why it's so important to latch in particular, prior to age 22. All right, so supplemental security income, in order to get it, you have to meet the definition of disability. And so on top of the financial test that you have to have assets below 2,000, and there is an income test, you have to meet the substantial gainful activity definition. And so basically, you're no longer able to perform substantial gainful activity as a result of a physical or mental impairment that is expected to last at least 12 months or possibly result in death. And the substantial gainful activity, it's basically you're unable to make, this year it's $1,550 per month. Okay, and so if you're able to make $2,000 a month, they're going to say, I'm sorry, but you're not disabled pursuant to the Social Security definition. So once again, whenever I talk about disability, it's a lot more of the functional stuff. They're saying just because you have a diagnosis, that doesn't mean that you can't perform any job whatsoever and make at least $1,550 a month. It's important to note that the sole purpose of SSI is for food and shelter, nothing more. The federal government essentially says, yes, we want to make sure that we can help put a roof over your head and food in your mouth. But other than that, we're not going to be responsible for shoes on your feet, clothes on your back, your brand new computer, none of that. And that's important to understand as we're going to be moving into some of the rules as it pertains to SSI. It's also important to note that for a lot of my families, they cannot apply until age 18, because essentially we as parents have a duty to support up until age 18. And for child support purposes beyond that, but we're not going to get into that today. And so once a child turns 18, the parent's income is no longer deemed down to the child. They have to ignore it. And so that's whenever we can start establishing eligibility for a lot of my clients. All right, so if you recall, I said that the sole purpose of SSI is for food and shelter. And so what happens is in the Social Security world, in particular for SSI, there's what's called an in-kind support and maintenance reduction. And essentially what the federal government has said is if you can get free or reduced food or shelter, then basically you're going to get a 1/3 reduction. And so even though the numbers right now, it's $943 a month is the max SSI amount, I know that if somebody is not receiving that amount, that there is a reduction. Usually the amount that is coming in at the reduced amount is $678.50, which is the 1/3 reduction amount. And what that tells me is the family is not charging for food, they're not charging for rent, and as a result, their kids are getting this 1/3 reduction. In some circumstances, it's 1/3 plus $20. That's a very rare circumstance, but if it's off by $20, I know that that's what the issue is. It's also important to know that there are special rules in terms of other income. Okay, so just because you're receiving SSI, you're below the asset test, doesn't mean that we're safe in terms of any other additional reductions. So what the rules are is if you have unearned income, we're going to reduce that by $1 for dollar, and there's going to be a $20 disregard there. So I use structured settlements as a good example of this because I do a lot in the personal injury realm. And an annuity is an income for Medicaid, even though it's not an income for tax purposes. So what happens is for every dollar that structured settlement is paying after the first 20, then what happens is it's $1 for dollar reduced in SSI. For earned income, they want to encourage people to work. And so what happens there is that they disregard the first $65, and then it's 50 cents on the dollar reduction. In the event that there is a total loss, then what will also happen is you may be ineligible for what's called age-blind disabled Medicaid. Now, that said, we do have expanded Medicaid coverage now, so there's other ways to go about getting traditional Medicaid coverage, but we could run into some issues under the waiver programs and stuff like that. You can lose assets if you have, or you can lose SSI if you have assets over the $2,000 limit, if you have too much in earnings. And there's two ways that you can lose it in terms of earnings. So either you have gross earnings in excess of the $1,550, because I've already told you, if you're able to make that much, you're not disabled. And then if you, let's say you're getting your 1/3 reduction, so you're down to $678 and you're making $1,500 a month. Well, based on the $65 disregard, the 50% per dollar earned, you're not going to receive anything from SSI merely because because of all the other deductions that you're going to have as a result. You'll still be considered disabled, you're just not going to get a paycheck from the Social Security Administration. All right, so when we talk about resources, what is a resource for SSI purposes? And essentially, they're going to look at anything that can be turned into cash. This is going to include cash value on life insurance, for instance. If you're over $2,000 on the first day of the month, then you're going to lose your benefits. Literally, if you're at $2,000 and 1 penny, you are considered to be ineligible for benefits. There are some exceptions under policy. So if you're on SSI, you are allowed to own a house. You can have tangible personal property. You can have 1 car, and that's for an entire family if I have a family on benefits. Prepaid burials, we have ABLE accounts now. So there's a couple different tools that are going to be available there. However, an inheritance itself is going to cause a problem if it's not in a special needs trust. And so that's where a lot of my families have to, start looking at different planning. This is why it becomes so important for us to latch into Social Security and get that disability determination as soon as what we can. And so inside the program, we have our regular SSI. A lot of my family is okay, it's $943 a month. We don't have to worry. We don't want to worry about assets. We don't want to worry about reporting. We don't want to worry about all this stuff. So there's a couple different ancillary things that happen under a parent's work record. Okay, so number one, you have retirement benefits and you can collect anywhere between age 62 to 70. You have to have at least 40 work credits to get there. So if I have somebody who maybe became, and they're in those age brackets, we might just select retirement. We have SSDI, which means you have had work credits, but now you're disabled. And so they're going to pay you out just regular disability benefits. Where this becomes super important is the dependent benefits. Because in the event that a parent and your child is still a dependent of yours, if you become disabled or you retire, your child actually gets to claim half of your benefit, provided they were considered to be disabled prior to age 22. And it is very, very difficult to get the Social Security Administration to go retroactive on a disability determination. So I encourage my families to immediately try and get their child eligible for benefits at age 18 so that we can get this benefit. One of the questions that families often ask me is, so is this going to impact my personal benefit? The answer is no. You get to collect your full benefit and your kid gets to collect your 50% of your benefit. When you pass by latching in, your child now gets to claim 34. They get to claim 3/4 of your benefit. And so this can be instrumental and much more than that $9.43 a month to be able to support your child whenever something happens. There's also survivor benefits. And so these are available then for spouse and children based on spouse's record. The benefit for a child is that 3/4. It's important to note that if your child gets married, they are no longer your dependent. That will sever any rights to be able to collect anything here under. We're not really going to get into the details right now, but there's a big movement to try and undo that because it creates an unfairness in terms of, you know, a lot of times an individual with disability is marrying another individual with a disability, and neither one are technically going to be able to support each other. And so trying to be able to latch into parent work records. So that's kind of a movement that's going on right now in terms of special needs legislation that I'm aware of. All right. Let's talk about the hypothetical. Just kind of give you guys some numbers for those of you who are number people. If John's receiving SSI of the full amount of $9.43 per month, John's father, Joe, is going to retire and he's receiving $1,400 a month. John is now going to actually receive $700 per month from his dad's work record. Now, mind you, it's an unearned income. So remember, it's a $20 disregard and then a dollar for dollar reduction. So what's going to happen is basically he's going to end up with $20 more than what he did before. And that's because of that $20 disregard. And so now he's going to receive partial SSI of $263 a month and regular Social Security disability of $700 per month. So in these cases, you are going to see two deposits. People are often confused about it, but that's what that is. All right, Medicaid. Historically, there have been two major programs. So you've had your CHIPS program, which is your family program, and it's a totally income-based. You can have $1 million worth of assets and still get CHIPS Medicaid, as long as you're not working. And then you have what's called ABD Medicaid, which stands for aged, meaning over the age of 65, blind or disabled Medicaid. This is where you get your income and your asset tests. This is also where you're going to find your waiver programs. And for those of you who are familiar with the waiver programs, this is the holy grail. That right there is why people need Medicaid in place. So yes, some people actually need it for the traditional health insurance, but really it's about being able to get care inside the home to be able to pay for residential settings, whatever that may look like. And those waiver programs are where it's at. The rule of thumb for ABD Medicaid is as long as you're receiving $1 worth of SSI, you are going to automatically be enrolled in ABD Medicaid. That program will have a $2,000 limit, which mirrors the SSI limit. Great, it's easy to track. So a lot of people get frustrated because, as I said, the waiver program is the holy grail of the Virginia system. I like to use this chart because for my families who are on the waiver waiting list, which can be a 20-year waiting list, they often don't understand, like, why are we waiting so long? All right, and so this chart's a little bit old, but I think it gives a good visual based off of the year. And this is before expanded Medicaid came into play. But if you have a total enrollment of about 1.2 million in the Medicaid system, and only about 12% are in what's in that ABD program. However, if you look at from the $8 billion for this year that we were looking at here of expenditures from Medicaid, you know, the vast majority of the expenditures that come out for the Medicaid program are for that very small 12% of the population. The reason why is really because, number one, care needs are higher, you know, much more frequent and intense, you know, hospital visits, and, you know, we've got a lot of medically fragile kids, but also because of the waiver programs. The waiver programs are very, very expensive to maintain because it's one-on-one care. And so even though the program the caregivers may only be receiving about $13 an hour, you know, the people who sponsor may be receiving a little bit more than that. We're estimating probably about $20 to $22 an hour. You can't spread that care among multiple people, right? It's one-on-one care, which means that if we're allocating 56 hours per hour or per week for that one child, instead of being able to allocate between multiple, like you can in a facility setting, this is one of the reasons why it's so expensive. This will also apply to the in-home care waivers for my elderly people as well. There are two major waiver programs. You have your My Life, My Community waiver program, which is for individuals with developmental disabilities. You also have your CCC Plus program, which is also going to apply for anybody who needs a skilled nursing level of care. All right. We do have expanded Medicaid. So if I have an individual who maybe is not self-sustaining, but not necessarily meeting the definition or not yet on SSI, in the event that we don't have any income, for instance, this is a bridge the gap policy of Medicaid that happened with the Obamacare. And what happens now is as long as you are under 138% of the federal poverty level, and that's all based on family numbers and everything else, then you are going to be covered under the state Medicaid program. It's an income-based program. But prior to Medicaid expansion, if you had no money, but you were over the age of 18 and under the age of 64, you would not have been eligible for Medicaid. So there are times where, especially in my like personal injury settlements, where I ignore like ABD Medicaid, for instance, we give up SSI because there's a bigger benefit to having access to the money. And we have to talk it through with the family, but they can use this Medicaid program as opposed to the ABD Medicaid program. I saw there was a question. Okay, so is ABD waiver the same as the CCC Plus waiver? So ABD is the category of age blind disabled. Underneath there is the waivers, and we have a couple different waivers, but the big two are your CCC Plus, which is for skilled nursing care. So you have to need assistance with activities of daily living. So it's the feeding, bathing, dressing, walking, going to the bathroom, and transferring. And you have to be at risk of institutionalization for that one. And then you have your My Life, My Community waivers, which are for your developmental disabilities. And that is your holy grail right there. That's the one that everybody wants because it's going to just stay with that individual for life. Technically, it's supposed to cover around the clock care. Did that answer that? All right. The Affordable Care Act, that's an option too. So sometimes I do have families that are above the 138% of the poverty level. In those cases, we may look at some Affordable Care Act options, especially if we might be working part-time jobs and stuff like that. Not every state has expanded Medicaid, so this is an option in those states. Luckily, Virginia was good to adopt it. All right, other potential benefits that we look at might be Section 8. It's important to note that there was this big case, it was called DeCambery, and it ended up in the federal circuit courts because the state, it was Massachusetts, and they were basically penalizing people with special needs trust. They were saying that all the income in there counted as income for Section 8 housing and was increasing the amount that they needed to pay. Whereas had a person without a disability had the money sitting in their bank account, they would not have had the same restrictions. So that's a case that I know some of my colleagues up in Massachusetts were heavily involved in. We can also look at food stamps and legal aid and utility assistance. But once again, usually these are the minor benefits. What my families are really looking at is making sure that we have a consistent income source and making sure that we have those Medicaid waivers intact. All right, so what we're going to do now is we're going to move on to planning for somebody with a disability. All right, and basically this is going to include, you know, if we have child support, if we have any minor accounts, 529 accounts, you know, no plan at all, the trust is a bad trust, we've completely disinherited somebody. These are all things that I have to look at as problems in planning. And whenever I use the disinheritance stuff, there was this whole train of thought a long time ago that you just disinherit the person with the disability and their sibling or whoever is going to take care of them. Well, the problem is that doesn't always happen, right? So child that you left the money to, he dies, new wife, or, you know, the wife says, nope, it's mine, I'm not using it to take care of you. Or we have creditor issues or whatever the case may be. So That's probably one of my least favorite things on here, because we have tools in place to specifically leave an inheritance for an individual with a disability without disrupting benefits. In the event, and this does happen like more often than what it should, but in the event that there is a trust for an individual with a disability that it does not satisfy the terms of a special needs trust, then there is a process called decanting that I can use to fix it. Unfortunately, like I said, I have to do this more often than what I want to. One of the things I'm normally looking at is, do the words health, education, maintenance, and support fall within that trust? If it does, from a public benefits perspective, it's available for support and maintenance. And so the public benefits agencies say, no, you can use your trust before we're going to pay you. Remember, these are not entitlement programs. These are payers of last resort. And so if they can find a way to not have to pay benefits, they're going to save their money and say, no, somebody else can do so. It's funny because I get a lot of people who say, well, I called Medicaid and they weren't helpful. They didn't tell me what to do. They're not, telling me how to spend down the same way that you are. I'm like, well, their job isn't to get you eligible. Their job is to review the application and say yes or no. So they're not there to help with getting you eligible. Every once in a while, you do get a very good eligibility worker who's sympathetic. The other thing is child support. So this happens more often than not, but just remember, child support is the child's money. So the child support does have to get directed into a special needs trust, because otherwise it's income to the child, which will impact benefits. It has to be directed to the special needs trust by court order. It cannot be directed based on just a basic agreement. And so that is something that sometimes I have to get involved in, move things around. Your own planning, what we need to consider is making sure you have a really good power of attorney in place. There are certain provisions I put inside the powers of attorney that I do that, for instance, allow for you to continue to support your dependent child, and also allow for gifts to the dependent child. So if they're unable to work and you've got multiple kids, there's a couple different things I need to do. Number one, that child that's living at home, well, you're paying for a portion of their utilities. We need to continue that if something happens to you. Similarly, if you always pay for the new clothes, or of course you want them to get the new computer, and you don't want restrictions as it pertains to that kid, well, then we need to put that in the power of attorney. Similarly, can we create a trust later on down the road? These are all what are called hot powers. And if you step back and think about it, there are some things that are so personal in nature to us as individuals that we do not want other people to unilaterally be making these decisions. And so we have to very specifically spell out, can we gift to all kids? Do we consider one kid over the other? Can it be outright or in trust? And so whenever I see a lot of powers of attorney for my families that have kids with disabilities, these are things that I do not see in the power of attorneys, and I often need to clean up. Wills and trusts, we do not want to provide outright gifts. We do not want to say, and I give, 1/4 of my estate to my son, Joe. No, it needs to go into the special needs trust for Joe. The other thing we need to think about whenever we're doing trust, wills and trust planning is, does that individual need more support? And a lot of times it's going to be based on the plan. So for instance, the family I met with earlier today, we're going to be leaving the house to the individual with the disability, because he is going to remain there. The siblings, if they want to come move in and help provide care for him, that's great, but we don't want them forcing the sale of the house because they want the money. We want to make sure that that house is available to that kid. And so obviously they are going to need more support to be able to maintain that house as well. And so sometimes it's not an even split. On the flip side, I have families where their loved one is inside a facility and Medicaid's basically covering 100%. They have very little extra needs. Well, then that kid may need less support. And so it's walking through those types of things. It doesn't automatically have to be an equalized split. Same thing with retirement accounts, bank accounts. Any of the assets you have, you never want to name the individual themselves as the beneficiary. You want to name their trust. And we're going to talk about the different types of trusts here in a minute. So when we talk about this, we talk about it from you guys as the parent level, but we also talk about it at the individual level. So fundamentally, we just kind of briefly touch base on powers of attorney and advanced directives, or powers of attorney, but everybody, once they turn 18, should have a power of attorney and advance directive, provided they understand them. So a power of attorney and advance directive is not valid if they don't fundamentally understand what powers they are giving over and to whom they are doing it. In the event they can't make those decisions, they can't understand those documents, that's then when we need to consider a guardianship and conservatorship. All right, so usually you don't have both, you have one or the other. We're going to talk about trust, we're going to talk about military SBP, child support, all that fun stuff. All right, so fundamentally, here's what I'm looking at: surrogate decision making. In a power of attorney advance directive, we have a presumption of capacity because we are all presumed to have capacity at age 18. This is why whenever somebody turns age 18, we might start hitting some restrictions. In the power of attorney, we might not have any accountings, we might have a little bit more flexibility. There's no surety bond, which is basically just an insurance policy saying you're not going to steal anything. We might still need a representative payee. We'll get to that in a minute. In the guardianship and conservatorship arena, a judge has to determine that somebody is incapacitated, and the court will decide who will be making decisions for that individual. And sometimes it gets contested. Those are not my favorite cases. You are going to have to account for any money that you manage to the court. And the courts basically say, hey, we're entrusting you with the money. We need to protect this individual. You will have to post that surety bond that says if you stole money or you mismanaged it, the insurance company is going to put the money back in and then they're going to come after you. Not a fun process. Once again, we may still need a representative payee. And what is this thing? So basically, when you're dealing with federal benefits, so we're talking about Social Security, VA, DFAS. Basically, if you go back to civics, which it's funny because my little third graders, they're starting to touch on civics. And so we started talking about some of this stuff. But if you go back, anything not expressly reserved for the federal government is a responsibility of the state. And so powers of attorney and guardianship laws are state by state creatures. They're not federal. And so now we're dealing with state creatures of authority, but we're trying to deal with federal benefits. And so the representative payee process is essentially the federal government entity appointing somebody similar to like a guardianship and conservatorship to make the decisions as it relates to those benefits and be accountable for them. All right, capacity. When I'm talking about capacity, one of the things that I have to look at is I need to assess it outside the presence of the family. And the reason why is that if I see a lot of deferring to the family and the family's talking for the individual, I can't determine what this individual understands. And so sometimes I say, I'm sorry, but I'm going to have to get you to leave the room. I try to do that, especially with my families when there's disabilities, because I try to wait a little bit so that the individual is more comfortable with me before I do that. Because if I'm like, sorry, you can't be in here, you need to go, that's not necessarily, doesn't put anybody at ease. Fundamentally, for the power of attorney advance directive, they have to understand the nature and the consequences of the document. And so, big picture, do they understand that they're appointing mom and dad to continue to be mom and dad? Do they understand that mom and dad are still going to be able to make their decisions for them? That's really what I'm looking at. We do document capacity. We do that through the witnesses. And in the event that there is some marginal capacity, we're going to document very, very detailed through a memorandum. If in doubt, if there is marginal and I don't know which way to go, because I am not a doctor, I will obtain the physician's opinion. Sometimes they don't like to comply. I just had one on Monday where I had to subpoena them to court. So, it is what it is. A lot of the pediatricians, especially like over at CHKD and EVMS, they're very, very good about getting me the forms that I need. All right, so it's important to understand powers of attorney are going to be strictly financial. And in particular for an individual with a disability, I want to make sure that I have the ability to create a special needs trust for them if and when necessary. So that way, if grandma left them $100,000, we can easily get things cleaned up, so we're not disrupting benefits that are in place. It's important to note that the power of attorney will survive incapacity, and it does create a fiduciary relationship, meaning you can get sued if you mismanage things. Everybody thinks that it's fun and games to, be in charge, but let me tell you, it is not whenever you mismanage things. And basically the terms of that power of attorney are going to govern. So basically the form you get off of LegalZoom, it's going to allow you to transact on behalf of the individual. You are not going to have your hot powers. You are not going to be able to set up a first party special needs trust. Advanced medical directive, this is going to allow you to make medical decisions. And this is one document that should be prepared in the state where the individual lives. So as you probably are aware, we do have some death and dying states or dignity and dying states. Virginia is looking at implementing those, which means that all of my documents are, going to be out of date, which I'm not looking forward to. But, we want to make sure that if a state allows for something that we can put it in there. Your advanced medical directive is actually 2 documents in one. So it's going to have your living will and it's going to have your medical power of attorney. So essentially, in the event that you have a terminal condition, you're in a persistent vegetative state, do you want life prolonging measures? Do you want feeding tubes? Do you want IV fluids just keeping you alive? And then your medical power of attorney. So it's going to appoint somebody to make your decisions for you. Now, it's important to understand that this document is only effective when you're unable to make your own decisions. I have a judge client, and whenever I was doing his documents, we had a discussion because he did not like that in there. And I was like, well, Your Honor, I can't really, fix that. That's what the law says. And he was like, no way. And like, he's arguing with me. And so I pull out the code section, I show him, he's like, well, I guess I'm stuck with it. So 2 doctors have to opine that you are unable to make a decision for yourself. Although that will include a HIPAA release, a lot of times, especially whenever I have people who still have some ability to make decisions for themselves, but they heavily rely on their parents, then what I'm going to do is I'm going to do a separate HIPAA release that will follow the individual. So a lot of practices will allow people to sign and say, okay, you can contact or this person, you can communicate with, but we do a document that follows the individual anywhere in the country because it's national law. So that way you can, still engage in the things that you did as mom and dad, even if you might not be able to make full decisions from a medical perspective. Then you have the guardianship and conservatorship, and essentially this is required when an individual is wholly incapacitated. I just did an hour presentation for senior advocate earlier today on guardianships and conservatorships, and essentially incapacity means that you're unable to either meet your health care and safety needs without the assistance of a guardian, and you're unable to manage your financial affairs without the assistance of a conservator. It's important to know that the guardian is of the person, so you're going to be deciding things for residents, medical needs, education, employment, whereas the conservatorship is strictly financial. These people are often the same people, but sometimes they can be different depending on the circumstances. What are the duties? Essentially, the duties of the guardian, you're going to have to file an annual report to Department of Social Services. The law changed in July to where this is much more strict. So for those of you who may need a guardianship and they're just getting ready to turn 18, I am going to apologize on behalf of the Commonwealth of Virginia for you because you have a little bit more in-depth reporting, especially if like you are trying to transition them, let's say, into some sort of group setting. Because now there's a requirement that the guardian meet at least 4 times with the individual, 2 of which can be delegated out to somebody. And so this has created a little bit of a problem for my guardians that may live out of state, but it is what it is. It's the law. We got to do it. Conservator, basically, you're going to have the same fiduciary duties as a power of attorney, and you are going to have to file annual accountings with the Commissioner of Accounts. This isn't an extra cost. So when I can do a power of attorney, I want to do the power of attorney, because you're still just as responsible and liable, but those annual accountings with the commissioner can often be a very big burden for my families. Now that said, I'm talking about my special needs families because my elderly families, it's a completely different scenario. There's normally assets and a lot of fighting about who's going to manage it. Qualifications. So if you have a felony on your record or you file a bankruptcy, the courts may not entrust you to make decisions for somebody else. In particular, if your bankruptcy is recent, essentially the courts are going to say you couldn't manage your own money. We're not going to entrust you with somebody else's money. So that can become a problem for some of my families. The guardianship doesn't have that surety bond on it. However, I've done this enough now to where I can get surety waived on the conservatorship if there's less than $25,000 worth of assets that we're covering. So there is an exception to policy. Unfortunately, I see way too many guardianship attorneys that are not doing that. And so the families are paying for the surety bond that they could have otherwise gotten waived, which is not good. It's also important to note that just like the power of attorney, where there's some things that are so personal in nature to us, The same thing's going to happen with a guardianship conservatorship. You may require court permission for certain things. So for instance, a divorce. To initiate a divorce, you're going to have to get express approval. It is not going to be, because trust me, I've had clients ask me, as the child, I don't like my stepmother. Can I initiate the divorce? Nope, we're going to have to prove why it's necessary. Same thing with like selling a house or making gifts, all that fun stuff. If it's not specifically in your court order, you're not going to be able to do it. All right, so now we're going to get into some of the meat and potatoes. So a trust, by its very nature, it's just a separation of what's called legal and equitable title. So it's going to be a legal contract to control property. The trustee has legal title, and they're required to manage pursuant to the terms of the trust for the benefit of the beneficiary who holds equitable title. There are a couple different types of special needs trust, but basically a special needs trust is just drafted in a way to where I always say like it's a candy shell over it that Medicaid can't look at what's inside of it. And the key word inside these trusts are that they are used to supplant, or they're used to supplement, not supplant public benefits. And once again, if I see the words health, education, maintenance, and support in there, well, that's my first problem inside of reviewing a trust. All right, so these are your two different types of special needs trust. You've got a third party and a first party. Your self-settled special needs trust, there's two different types. There's what's called a D4A, or often just referred to a self-settled trust, and a pooled trust. And then in your third party arena, you have a standalone trust, which can either be inter vivos or testamentary, and then a pooled trust. A pooled trust is basically for smaller accounts, and usually what they do is they do like a pool of investments. Everybody has their own account, but everything's going to be invested kind of the same way. So that way it's easier to manage, lower cost, those types of things. Inter vivos means that it's created during lifetime. It's effective during lifetime. So if I'm creating a revocable living trust, there is a sub-trust for a special needs trust in there. That is going to be an inter vivos trust. In the event that the trust is created under your will, that is what's called a testamentary trust, because a will is a testamentary document. So those are going to be the differences there. Whenever I look at the rules, this is a little chart. And for whatever reason, like depending on what screen I'm on, these things merge differently. Your first party trust, we're going to have limitations on who can establish them. It has to be the individual themselves, parent, grandparent, guardian, and court. What's going to differentiate, and the third party, anybody can do it. What's going to differentiate what trust I have to use is based off of the assets that are going into it. If it is the asset of the beneficiary, such as child support, I have to use a first party special needs trust. If it is the asset of a third party, such as an inheritance, it's yours and you're saying put it here, then I can use a third party trust. And, there's a bunch of different stuff up on the screen, but big picture, what my families don't like about first party special needs trust is there is a Medicaid payback. So that, and there's an age limit of age 65. After age 65, I can't put any more money in the first party special needs trust because congratulations, we are all presumed to be disabled. And Congress, when they implemented this, did not want my elderly clients to be dumping all their money in a first party trust for Medicaid benefits. The Medicaid payback, it's a federal rule. I can't get around it. And how I normally try and explain it to my families is that it's the can't have your cake and eat it too rule. If you go back to the spreadsheet where it talks about the costs there, the most expensive part of having a disability is going to be the medical costs. And so what Medicaid essentially, and what the federal government did when they created this thing, is they essentially said, that's fine, you can use as much as what you need during your lifetime, but at your death, it's not going to just go to your family. We're going to get repaid back before it goes anywhere else. So what happens in these scenarios, though, is that they look at how much is in the trust. So if I have $1 million Medicaid lien and only $500,000 in the trust, Medicaid's going to take it all. And then if I have let's say a $500,000 lien and $1 million, in the trust, then Medicaid will get paid back the $500,000, and then the remaining $500,000 will be available for, whoever the remainder beneficiary is of that trust. Remember that Medicaid payback is only applicable to your first party special needs trust. That is not for the third party. So a failure to plan is planning to fail, as I usually say. if you do not do planning and you die without having these trusts in place, your child has now received the benefits. I am going to have to do a first party special needs trust subject to that Medicaid payback. However, if you do the planning and you set up that third party trust, you update all your beneficiaries to say, yep, it's going in this trust, then we will not have any Medicaid payback on the death of your beneficiary. What are some funding options? You know, we're all, you know, trying to raise kids and everything else at this point in our lives. And so sometimes we don't have the liquidity to just dump inside of a trust. So life insurance is a really good option to look at. As I said earlier today, the child with the disability is going to be the sole receiver of the house to make sure that he can stay there. And if it's sold, the kids have no benefit to sell it because the money's all going to go to that child anyways. Yes, we're going to look at putting cash and investments in there. Child support goes in there. Your retirement plans. This is very important because, you know, we all have kids right now in the school system if we're on this call. And your retirement plans, such as your military TSP, your 401k, your 403b, your 457b, your IRAs, you've not paid taxes on the money that's going in there. And so what that means is as it's coming out, it's taxable. There are some rules under what's called the Secure Act that makes it more advantageous to leave those assets to an individual with a disability than to your other kids. The reason why is your disabled child is going to have the ability to do a lifetime stretch for those assets. Whereas now, and this became effective, I think in December 2019, if you are not an exception to the norm, you know, to the major rule, which is for like spouses, people between, you know, within 10 years of the account holder, a person with a disability, you have to pull out over 10 years. So if I have $1 million IRA and I leave it to child A has to withdraw that over the course of 10 years. And so in that case, it's $100,000 if we pull out equal installments, $100,000 per year of taxable income coming out. Where if I can divide that up and stretch it out longer, it's going to reduce down the tax consequences. So that's a very important part of planning. The other thing is the survivor benefit plan. And so that's your military pension. There is the ability to elect for a dependent child benefit. They will receive about 55% of your benefit. And so a lot of my military retirees, I work with them on this. The interesting thing is, and it's so easy for us to say, okay, well, child support, no, like that's not, like that's mine as the parent to take care of my kid. Or, and same thing with the SBP, well, I paid into the plan, like you know, because I think it's like $20 a month or whatever to maintain the dependent child benefit. But, you know, it's my benefit, it's not my kid's benefit. The federal guidelines on the SBP specifically say that must be directed to a first party special needs trust in order for it to be exempt for policy purposes. So that is one benefit that I can't do much about it because of federal policy. They say it's the kid's benefit. All right, I've already touched on child support earlier. This is a lot of stuff on the screen, but essentially this is involving your qualified funds. And so your Roth IRAs, you're not going to have any penalties due to a disability. There's not going to be the major tax consequences because you've already paid taxes before it went in there. Your 401k, and I'm going to just say like you become disabled and you have a 401k. What this does is it allows us to roll over so if you become disabled and you now need to move us in a special needs trust, there is a PLR and that's a private letter ruling from the IRS that essentially says, sorry, we're not going to let you do this. It's a grantor trust, meaning that's your income. And so no, we're just not going to let you do this. That is very contradictory to 3 other PLRs that we have. So those other 3 up top, where they say if you have an inherited IRA, so if you accidentally name your child as the beneficiary of your 401k or your 403b, it now becomes an inherited IRA. And these 3 private letter rulings are saying, but it's okay to roll that over into a special needs trust because it is a grantor trust. And so it's just kind of interesting that we do have this policy where if it's your own thing, you can't protect it, but if you've inherited, you can protect it. So it's just kind of one of those things to be aware of over there. And the structure to take the hit over a few years. I did have a case where The lady had cerebral palsy, but she was able to work at a call center for quite a bit of time, had her own 401k. And so we had to discuss, are we going to take the tax hit over a few years, or are we going to liquidate it all because she desperately needed the in-home care due to her carpal tunnel and stuff like that. She couldn't move herself in her wheelchair anymore. And so those are just kind of like tax discussions we have to have. You never knew that my life was just going to be so exciting and I got to do with taxes so much. But let me tell you, I'm smack dab in the middle of tax season right now and working on all this stuff. It's important, and this is kind of an exception right now, but it is important to understand that some beneficiary designations and some trusts may cause a disruption. Major policy is that if you name a charity as a beneficiary after your first beneficiary, it could be what's called an atom bomb beneficiary and blow it all up to where we cannot take that lifetime stretch. There is an exception now being built up under the Secure Act for a special needs trust. So that is nice. But if I have, say it's just, your son, he's not disabled, it's a regular descendant separate trust, and then you wanted to go to charity afterwards, that will blow it up and your child will not have to pull out over 5 years as opposed to 10 years. All right. I am running short on time, guys. Let me go. So I'm going to go through ABLE accounts. I do have some examples on here and I will send out my, my slides, but big picture, ABLE accounts, these things came out a few years ago. And the whole purpose of them was to encourage the private wealth to fund disability related expenses. As of right now, and there's a movement to change this age, you have to have been disabled prior to age 26 and either receive SSI or SSDI or file a disability certification in order to open up the accounts. It's important to understand that they can't exceed the annual gift exclusion, and I don't know why I didn't update this. It's currently $18,000 you can put in there. And each state will set the totality of what you can put into these things. So in Virginia, you can't have more than $300,000 in it. If the value exceeds $100,000, then SSI is going to suspend until your account is back below $100,000, but your Medicaid will be unaffected. Under federal law, there is a Medicaid payback in these things as of the date in which the account was set up. There is an exception for Virginia residents where Virginia by statute has said that they will not come after an ABLE account. So that's one nice little thing. But I use these in very few exceptions. And that's just because there's a limitation on how much that I can put in here. These are some examples of disability related expenses. And essentially, as long as it's for the benefit of the individual and not going to something unsavory, then you're going to be able to use the ABLE account for it. If you put too much in a year, it's going to not be considered an ABLE account anymore. And if you do pull it out for something that is not a disability related expense, then it's going to be subject to regular income tax and also a 10% penalty. The states may also impose additional penalty. If you had a child that you have set up a 529 like regular educational account for, there was some legislation that was passed that will allow us to now roll over into an ABLE account. That was something that the Treasury would not do, so we had to fix it by legislation. But some of my families, they start saving, they don't know that their kid is, or like maybe there's a later onset of a disability. And so this is now a little tool that we have. The rest of presentations are hypotheticals about how this stuff all works. And so what I'll do is, like I said, I will pass the presentation around so that you guys can see those hypotheticals. Are there any questions? I don't see any on my end.
I don't see any questions. You've provided a lot of good knowledge for them, a lot of good information.
It's always a lot of information.
And Frankie, you've heard this a very similar version of this 3 times now, and you're probably still learning stuff every time, right?
I do. I always learn a lot. It is always a lot, and it's very valuable information.
So I would like to thank Shannon for presenting information to our families tonight regarding future financial planning. If you have any questions, please contact Dr. Frankie Dampier via email, which is Frankie Dampier@cpschools.com. She will be more than happy to answer any of your questions. This webinar has been recorded and it will be uploaded to the Chesapeake Public Schools YouTube page within the next several days. Thank you for joining us this evening. And remember, families and communities work better together.